Hello, I'm Ross Downs. I'm an attorney licensed to practice law only in the states of Louisiana, Arkansas, and Mississippi. This video does not constitute legal advice. The video is for general informational purposes only. The viewing of the video does not establish any attorney-client relationship of any kind, nor is it intended to do so. And finally, we do not wish to represent anyone wanting legal representation in any states other than Louisiana, Arkansas, and Mississippi. And today I wanted to talk to you briefly about aggravation of pre-existing conditions. Typically the law in most states, as I've read it over time, basically says something to the general effect that a tortfeasor, a person that commits a wrong, that breaches a duty or violates an obligation, takes the victim as he or she finds them. So if someone has had pre-existing problems, prior injuries to the same body part, and then the person's involved in a traumatic event such as a car wreck, 18-wheeler crash, or the like, and then re-injures the same area, typically what we see in our practice is the law will provide that to the extent that the underlying condition is aggravated, and I always use the terms, even though it's not proper English, to the extent it's made worser. Everybody knows what that means. If it was made worser, to the extent it was worsened or made worse, then that is recoverable typically under the law, although each case has its own facts and circumstances, and an individual needs to consult with an attorney and have an attorney-client relationship to go through all of those mechanics and procedures. But in an aggravation of a pre-existing condition type case, it's important to understand that all of the prior medical records are going to be carefully evaluated, obtained, and looked through to see how the person was doing prior to the crash or the traumatic event. And then starting with the traumatic event at issue, what was the spike up, what was the increase, if any, in the underlying condition? And then, what length of time did it take for the person to go back to baseline, how they were prior to the accident or subject injury, whether they do or don't. And so it's more complicated than a pure new injury type case, someone, let's say, that had never had a prior injury. But just because a person has had a prior injury does not prevent them or preclude them from seeking compensation to the extent that the underlying condition was worsened or made worse as a result of the traumatic event. The best clients that I've seen in my practice tell the truth. They lay it all out there. They don't hide, fudge, exaggerate anything. They tell the physicians, the emergency room doctors, or other physicians or healthcare providers they see, they make a full disclosure of the prior pre-existing condition. They talk about what happened in the most recent traumatic event, what happened mechanically to their body, if they're able to tell those things. And then they lay it all out there and then let the doctors decide what treatment course is appropriate and what is necessary to try to get better. And then those individuals will hire attorneys that are well-versed and knowledgeable and have an experienced track record of handling these types of cases, knowing what the issues are and how to present these cases to a jury. So those are the things that we see in aggravation of pre-existing condition cases. Thank you very much.